Hello, and welcome to the first meeting of employment law. This is part of Ranken's Bachelor of Arts of Applied Management. My name is Matt Nagel. I will be your instructor for the next 8 weeks. A little bit about me. I'm a practicing attorney in St. Louis. I run the Bi-State Business Law Center, where we represent small to medium-sized corporations for a variety of corporate needs, including business litigation and advising them about employment law issues. So I have the great pleasure of having a lot of real-world experience on employment law practice and as well as theory in the course. This first meeting and in this presentation, the goal is to, number one, give you a foundation in American jurisprudence so you have an idea of where the law comes from, and number two, to explain how many of the assignments are going to work in this course. So first off, when we talk about the law, this comes in two varieties. The variety we are most often going to refer to is the law with a capital L. We're going to get into exactly what that means here in a little bit. But when we refer to law as a capital L, it encompasses a lot more than just words on a page. And as many of you, this is probably the first legal class you will ever have taken. It's going to be very challenging. A lot of the feedback I've gotten over the years of teaching this class is that students have struggled, but that light bulb moment comes on for them at some point, and then the clouds part, the sunshine comes down, and they start to get it. I promise all of you will have that moment where all of a sudden the legal class stops becoming such a challenge and it starts to become a little fun. But let's go ahead and jump into things. When we talk about the law with a capital L, what we mean is that employment law itself is a fragmented body of work. The law comes from a lot of different places, not just one book or not just one set of rules or regulations. I am tasked with squeezing about 3 semesters of law school into 8 weeks for you guys to give you a working knowledge of how this works on the ground. We are going to work to make sure you understand the basics and hopefully dispel a lot of myths people have about employment law along the way. My goal is not for you to walk out of here and be ready to practice law. My goal is for you to walk out of here and understand the basics, have a grasp of when a situation is potentially getting out of control, presenting a legal problem at work, and to be able to understand when you need to call the lawyers in, or when a policy needs to be reviewed, or when a procedure might need some tweaking. Because the best types of HR managers are able to recognize problems ahead of time, cope with them, and come up with policies, procedures to avoid problems before they ever materialize. Again, we want to anticipate problems in the system before they actually become problems in the courtroom. We want you to become proactive as frontline managers. So when I say that employment law is a fragmented body of work, that means the big L law comes from a bunch of different places. First and foremost would be constitutions. The U.S. Constitution is the granddaddy of them all, where all of the laws of the land of the United States flow from. We also have to look to state constitutions at the state level. As part of both state and federal constitutions, we have amendments as well. So we need to be aware of how those amendments are either changing the main body of the work or how they add and take different rights away. You are going to see that the constitutional amendments do carry a lot of weight in employment law as things change over time. Statutes. This is where the law is literally written in black and white. We commonly refer to these as laws with a lowercase l. These are passed by the legislative branch. So this is either your state Congress or the National Congress, the Senate, the House of Representatives, and they come out as bills that eventually turn into laws. We aren't going to take the time today, but this might be a good chance to go back to your Schoolhouse Rock days and see how a bill becomes a law. But this also encompasses things like city ordinances. So if the city of St. Louis passes a law, that's also something that employers in that metroplex have to follow. So one of the more common ones we're going to talk about is Title VII of the Civil Rights Act, which again is a legislative passage. We also have to worry about executive orders. The law, capital L, comes from the executive branch in the form of an executive order, where the president is taking a unilateral action. He's not asking Congress for their approval, and presidents can do this. There's a number of important executive orders we're going to look at over the years and over the history of American law. And this is something to understand because it's still going on today. Lastly, Lastly, we need to be aware of administrative decisions or administrative law that can affect our employment law understanding. So because Congress has so much to do and so much on their plate, they have taken pieces of their power and broken them up and giving them to smaller agencies. These agencies are in charge of one specific area of the law, and they are acting through the legislative branch to exercise that power. So one that a lot of people are familiar with is the EPA, the Environmental Protection Agency. OSHA is another agency that a lot of people are very familiar with. These agencies have the right to craft new laws, present them, and then punish people that break them, but specific to their area of practice. So for example, the Environmental Protection Agency can pass laws regarding the environment. They can assign punishments to that, and they can go out and punish people that break those laws. So they have both the power of the executive, the legislative, and the court system within their own small agency. And then perhaps most important is the common law. Common law are what we refer to as cases or judicial opinions. The American legal system is based on the English legal system, which makes sense. We were founded as English colonies. In the English system, they look to things that happened in the past to decide present disputes before the case. The way that's done is that after each case, the judge writes an opinion and says who wins, who loses, and why. This has two major advantages. One, we have consistent opinions. So lawyers, judges, and people involved in litigation can look to what happened in the past and figure out what is going to happen in the future. The judges use an application called stare decisis. This is a Latin phrase for let the decision stand. That means that they don't willy-nilly overrule each other. They try to let former decisions from the past control the future actions of people. This is very important in the American legal system because we have guideposts, we have signs, we have ways to understand how our behavior is going to be met, either by opposition, praise, or punishment. This stems from, again, our English history. Out of the 50 states, 49 all practice common law. The only oddball is Louisiana, who practices the civil law. And that is just more of a Jeopardy question, but that's because they were founded on French law. And the French system is based on civil law. That means everything has to be written down in terms of an ordinance or a statute, that they don't look to judicial decisions on how to act in the future. So when we're talking about common law, we are always going to be looking or reading a case that a judge has decided. Some of these judges are within the court system. Some of these judges are within an agency system that we talked about before. Either way, whatever they write down is supposed to guide people in the future. So these benefits are we have a very standard system that people can know what happens when they walk into a courtroom, or at least have a pretty good idea. But it also allows our system to be flexible and change over time. As society changes, our judicial decisions and our common law can change as well. Because we wouldn't want judges' decisions from 100 and 200 years ago to be telling us exactly what we can and can't do today. That doesn't make complete sense just with changes in technology, but also in the way that we view people in different groups of people in our community. Now, this change can happen fairly slowly, and I think we've seen a lot of that recently with the changes to gay marriage and the way that certain employment issues are treated. It's important to understand that these changes can happen very quickly, but they usually happen slowly as society changes. but you need to be aware that the law can change, and when it changes, your policies and procedures might not be worth the paper they're written on. So, in employment law, we are working within a civil law system. Now, this is different than the civil law that we talked about in Louisiana. Just kind of forget about those guys. So your courthouse is divided into two systems, civil law and criminal law. In the criminal system, you go to jail if you are found guilty. The prosecutor is the state or the city, and you are punished by sometimes paying money, but more often than not going to jail. The standard that the state has to prove in the criminal law system is beyond a reasonable doubt. So most people think about this as being 98, 99% sure of a decision. Very, very rarely are we going to talk about employment law in the context of the criminal system. Instead, we're going to talk about it in the context of the civil law system. In civil law, you are found liable or not liable when you are sued by another private party. You can also be sued by the government. So this is where two people can sue each other. All you are asking for in the civil law system is money. In exceptionally rare circumstances, the court can force people to do something, but those are so rare that we're not even really going to talk about them. So again, you are liable or not liable to pay money to another party, and the party can be the government. So nobody goes to jail, nobody's found guilty, and the standard of evidence the plaintiff has to prove is a preponderance of the evidence, so that you are 51% sure that this person is right and should win. So employment law occurs in a civil system where we are finding someone liable or not liable. Before we get too deep into the specifics of how that system works, during the course of your readings and over the course of the next 8 weeks, you are going to see a lot of these codes. And so what we have on the screen is Smith v. Jones. You are going to need to understand how to break this down and what this means. To a lawyer or a court, this is a roadmap. And this is a map pointing us to a specific argument in a specific case in a specific book on a shelf. I realize that it might be very confusing, so let's break this down. And not to mention, this roadmap is going to give us a ton of information in a very small amount of space. So in this case, Smith is either the plaintiff or the claimant or the appellant. The best way to think about this is that Smith is claiming he was wronged. Something wrong happened to him. In most cases, Jones is the person he's pointing that finger at. So Jones can be the defendant, the respondent, the appellee. Sometimes it's even a judge if Smith thinks a judge made a wrong decision. At the back end of this, where it says 8th Sir 2010, this is telling us what court issued this opinion. So Smith v. Jones is the name of a case where a judge issued an opinion between two parties that had a disagreement. Those parties were Smith and Jones. The 8th Circuit is the court that made this decision. We're going to get into a little more detail about the 8th Circuit here in a moment. We know exactly where this court is sitting, which is, again, important. So we know where in the country that happened. 2010 is the year the decision was published. So we know that this decision came down in 2010. The part in the middle where it says Southwest 2nd, this tells us which regional reporter the case is published in. In the United States, every appellate court and Supreme Court decision is published in a book called a reporter. Now, reporters aren't just a single book for each region. Think of it like an encyclopedia, right? You have the encyclopedia, but it's a volume of books, right? There might be 20, 30, 40 books. But that Southwest tells us which regional reporter that book is going to be, or that case is published in. So here in Missouri, we happen to be in the Southwestern Reporter. The Northeastern Reporter has Illinois, Indiana, Ohio. So these are also all going to be abbreviated. The Pacific region is the biggest region. It includes California, and a lot of employment cases come out of there. You'll see that abbreviated as P. Northwest, I know you're all in bated anticipation, is abbreviated NW. Southwest is SW. Northeast is NE. The Southern is S. Southeastern, SE. And the Atlantic is A. Each state has their own state reporter. The state reporters only publish decisions by the state Supreme Court. So, for example, in Missouri, there is an MO reporter. If you see the reporter is listed as MO, you know that is a decision from the Missouri Supreme Court. On the federal level, we have F, which stands for it was published in a federal court. We have US, which tells us it was the United States Supreme Court. So if we see something 5 US 10, we know that that is a decision published by the United States Supreme Court. Now the Supreme Court, because they are the biggest court of the land and the one everybody really, really cares about, they were published in 3 separate reporters. So LED, the lawyer's edition, is only Supreme Court cases. SCT stands for Supreme Court, and then again US. Interestingly, the same decision might be published in multiple reporters. If the Missouri Supreme Court issues an opinion, it's going to be published in the MO reporter. It's also going to be published in the Southwest, the SW reporter. If the Eastern District, which is a federal court, publishes a decision, that's going to be in the Southwest reporter, but it's also going to be in the F, the Federal Edition reporter. Same case, same words, just found in 2 different places. So think about each one of these reporters as a set of encyclopedias. The 13 tells us which book to pull off of the shelf. So if we have 50 books in the Southwest Second Reporter, we pull the 13th book off the shelf if we want to read Smith v. Jones. Now, the second edition, that just means that they have filled up all the volumes in the first edition and they have another. So in the Southwest Reporter, we're actually in the middle of the 3rd edition. This just means it's a separate set of volumes. So you just go to the shelf, you find SW, SW2D, SW3D. They just wanted to restart the numbering. The 85 tells us that the case Smith v. Jones begins on the 85th page of the 13th book. So pull 13 off the shelf, open it to page 85, and you see Smith v. Jones. 87 is pointing us to a specific page inside of that case. So you flip over a couple pages, and somewhere on that page is an argument that a lawyer or a judge is using to back up their position. So now we know where to go find that book on the shelf if we want to read Smith v. Jones. And we want to read that specific point that the lawyer is trying to make. The 8th Circuit tells us that this is a federal case being decided in the St. Louis area. And the way that we know that is the country is divided up into 12 separate circuits. Missouri, we happen to be the 8th Circuit. Now, this is a federal geographic breakup. Now, many of you are probably looking at the map and saying, wait a second, I only see 11 circuits. The 12th Circuit isn't called the 12th Circuit. It's actually called the Federal Circuit. It sits in Washington, D.C. It handles matters involving Washington, D.C., but it also specifically handles all cases with patent and trademark cases. The court system decided that these are so particular types of cases that require specified knowledge and training by the judges that they just want all these cases to be handled by the same groups of judges so those decisions are uniform, which kind of leads us to an interesting issue. The United States is a pretty big place, and people in different areas of the country have different values. The difference in those values and the difference in the law is reflected in the opinions published by each circuit. Just for example, because this is near and dear to my heart, the laws in Illinois are very, very different than the laws in Missouri. And being here in St. Louis, my arm's not quite as good as it used to be. I can't throw a rock from Missouri and hit Illinois, but pretty close. As soon as you cross that bridge, you are in an entirely different legal landscape. So you might read a case that was decided and published in the 8th Circuit, and the law could be completely opposite in the 7th Circuit. So as an HR manager, it is on you, and you have to understand what the law is in your state, in your jurisdiction. In jurisdiction, what that means is two things. Literally, where are your feet standing? What is the state? What is the county? What is the circuit you're in? And then also, what courtroom are we in? So are we in a federal courtroom? Are we using federal law? Are we using state law? State law and federal law do not always agree. Here in Missouri, that happens quite often. Anytime state law and federal law come into conflict, federal law controls. Federal law takes precedent over state law. So now we look at this citation. This is called a case citation. We know exactly where to go find Smith v. Jones. We can pull the book off of the shelf. We know what page in that book to look at for the argument that's being presented. And we know that this is a federal case that was decided in the 8th Circuit in 2010. So from this small bit of information, we gained a lot of knowledge, just to kind of give us a preview of what these parties might be fighting about. Now, I understand very few people have shelves of books like this anymore. You can type the same code into the internet and the case will pop up. Now, just another noteworthy tidbit. Every county in the United States is required to maintain a set of books that are considered the law in that county. You can almost always find these by going down to the courthouse, and they'll have a little legal library. In some smaller counties, they might have it at the library. But somewhere in every county in Missouri, there's a set of the Southwest reporters telling you that you can look up the law. They are trying to get away from some of the books and just provide online access. There's tons of legal research databases. You can look these up, like LexisNexis, Westlaw. These are a little pricey, so counties are trying to decide whether we go to keep our books or we switch over to these legal databases. So when we start jumping into what is employment law in the context of these federal circuits, these different reporters, it all starts at what's called the employment at will doctrine. The United States employs employment at will. And what that means is you can be fired for anything at any time unless you have a contract. Many people mistakenly think that as long as they're doing a good job, they aren't screwing up, they aren't causing any problems, they can't be fired. That is not true. That is a myth. If I came in to my office one day and I decided I don't want any brunette people working here, I can fire all the brunettes. Or I'm just walking into a guy's office, decide I don't like his face that day, I can fire him for that. You don't have to do anything wrong, just on the whim of your employer. However, there are major exceptions to this rule, and that is where kind of the fun of employment law comes in. I know many of you are not thinking that it's going to be fun, but I promise you we'll get through it together. So the major exception to the employment at will doctrine is if you have a contract. That is essentially how unions work. The union negotiates a contract with the employer, and the employer has to follow the rules in the contract, and the employees do as well. However, as history has taught us that as a society, we do have a tendency to single out people and groups that we feel are different to us, or that we feel are inferior to us. In those instances, they have been discriminated against. I'm sure you can immediately think of lots of examples of that. But the general rule is that you can quit anytime, you can be fired anytime, unless there is an exception to that created under the law. Contracts are the most basic exception, but the main legal exception, the thing we're going to mostly learn about in this class, are protected classes. Because of that history, and because we are trying to change that history, we have, as a group and as a government and as a society, decided we are going to protect certain groups of people from discrimination. And once you get past the employment at will doctrine, everything starts and stops with deciding if an employment action involved someone in a protected class. So it's a very fancy way of saying anytime something negative happens at work, you're fired, you're demoted, you're docked pay, you're not given a job, you're not given a raise, you're overlooked for some benefit. Was that negative action done as a result of you being a part of a protected class? And everybody is in a protected class. Let's take a look at these. So, think of protected classes as bubbles. And we don't want employers making decisions based on whether someone is in a bubble or not in a bubble. So race, or the color of your skin, protected class. Age is a protected class. Religion and gender are protected classes. Your sex is considered a protected class. And that is slightly different than gender. And it usually involves somebody harassing you because of your sexual nature, not necessarily just because you're male or female. National origin is a protected class. One protected class, another protected class that is in flux is sexual orientation. Heterosexual, homosexual, bisexual, disability and handicap, genetic information, this one's a little tricky, and then gender identity. And you'll notice on this chart that we have federal, yes or no. I like this chart because it reflects not only the current status of federal law, but it also reflects the law in Missouri. Now, if you're calling in or listening from Ohio or Pennsylvania, I cannot speak to what the protected classes are in those states, just because I'm licensed here in Missouri and Illinois. But all of these protected classes are creations of law. These are not necessarily just natural protections that you're going to get. There has to be a specific act taken by Congress or your state Congress to protect you. Now, most of these, so let's come at it from the federal perspective. The Civil Rights Act of 1976 created certain classes of people that said we cannot discriminate against them anymore. It was race, religion, gender, national origin, and sex gets kind of tied back in there later. Over the years, the government has decided that they are going to protect more classes of people. So age was protected through a separate legislation called the ADEA. Now, generally, when we're talking about age discrimination, there's people that are 40 and older. It really doesn't protect people under 40 very much at all. We decided we needed to afford additional protections to people that were pregnant. So they passed the Pregnancy Discrimination Act. The disability was added as a protected class under the Americans with Disabilities Act, and that has been added to over the years as well. Genetic information has been protected by an additional legislation that's probably the most recent one, which you'll notice that sexual orientation and gender identity are not protected at the federal level. There is current legislation before the House of Representatives to add sexual orientation and gender identity as protected classes. Now, that has not been brought up for debate, and there is no vote on it yet. It's still just kind of floating in limbo. But there's an opportunity for those with pending legislation to become protected classes. The state of Missouri has the exact same protections, the exact same protected classes. Again, this is because the states must adopt the federal law. At a bare minimum, the states must have the same protections that are afforded as the federal government. Now, Missouri is a very pro-employer state, so we don't have anything the federal government says we aren't required to. Now, just like the federal government, there is pending legislation to add sexual orientation and gender identity as protected classes, and just like the federal level, it's floating in limbo. No one's taking it up for a vote. With the recent Supreme Court decisions legalizing gay marriage, this might become a hot-button issue again. I would not be surprised if we see a vote on that legislation here very soon. The important thing to understand, though, is that everybody falls into one of these groups or these bubbles. That gender isn't just protecting women. It protects women and men. Race doesn't protect just African Americans or Hispanics. It protects everybody because everybody has a race. And what we're saying is we don't want any employer making an employment decision based because of someone's presence in one of these groups or classes. Now, rights that you do have under the various set of laws that we're going to get into and read into. You have the right to not be discriminated against, again, if you are in one of those classes, and you have the right to be equally employed, or at least the chance to be equally employed, again, not based on your classes. Now, if you don't get a job because you're not smart enough or you don't have the right qualifications, that's different. That's okay. Employers can pick the best person for the job, but they can't pick the best person on the job who's white, or they can't pick the best person for the job who is only a man. We want to even that playing field as much as possible. Under the law, you also have the freedom to engage in concerted activity and collective bargaining. Essentially, you have the right to unionize and have an elected group of workers speak on your behalf. The law also sets minimum standards for terms and conditions of employment, how many hours you can work in a week, what the conditions are like, how many breaks you have to give people. And we're going to learn about these laws specifically. We do protect some of your fundamental rights. These are child labor laws, what you can and can't ask people to do at the office. We're going to talk about the compensation you're going to get for different injuries or damages you get, either because your employment rights have been violated or simply because you got hurt in the procedure of your work. We're going to read a bunch of cases. Now, Turner v. Memorial Medical Center is a case that I am going to be publishing for you guys, and it's in your book. I'm going to walk you through exactly how to handle these assignments here in a second, but you're going to be breaking these things down and learning exactly what the judges are talking about. I understand that reading these can be very daunting, but again, I promise you that light bulb is going to come on at some point, and you're going to click. It's going to click on, and you're going to get it. These are going to make sense, and that you are going to be able to take a decision, read it, and then apply it to your own work or your own situations. So what do I expect you guys to get out of this class? What is it going to look like at the end? I'm going to expect you as a HR manager or a frontline supervisor with HR training to understand what employment laws apply to you in your job. Are you in a public sector job, which is essentially working for the government? Are you in a private sector job, which is, again, you have a private employer? Most of us are in that situation. Is this a unionized or a non-union workplace? Do we have the right to work in this particular state? Again, we need to know the state law versus the federal law involving unions. How many employers do we have? Because many employment laws only come into play if you have so many employees. Where are we located? What state are we in? What federal circuit are we in? What is the law for where our employer is located? We also need to know if we have any government contracts. Again, some of the employment laws only kick in and start to affect the way you do business is if you are taking the government's money. So affirmative action is one of these types of issues. If you don't take any government money, you don't have to employ any affirmative action. And then again, what kind of industry or